In a moment, I will show you that Aretha Franklin handwritten will. I promise you'll be surprised at what you're about to see. I'm an estate planning attorney. I'm an estate attorney. I handle a lot of cases dealing with wills and trusts in my career. And you might think that a lot of celebrities and high net worth individuals would have a good, valid last will and testament. And in a lot of cases, you'd be wrong. In fact, in the Aretha Franklin case, you'd be really wrong. In this case, Aretha Franklin had a handwritten will that was on a spiral bound notebook that was found after her death, stuffed in some couch cushions. In this video, I'll talk a bit about Aretha Franklin. I'll talk about the 3 competing wills that were found, and I'll also talk about what might have been done better from an estate attorney's perspective. I will show you that alleged handwritten will, and I promise you'll be surprised by what you see and maybe a little confused. But before you can digest this notebook will that was found, you need to understand a bit more about Aretha Franklin herself. She is the unquestioned Queen of Soul. And Rolling Stone named her as the greatest singer of all time, not once, but twice. Aretha Franklin is one of the world's best-selling musicians, having sold over 75 million records worldwide. The singer's most well-known hits include I Never Loved a Man the Way I Love You, Respect, You Make Me Feel Like a Natural Woman, Chain of Fools, Think, I Say a Little Prayer, Ain't No Way, Call Me, and many, many more. Aretha Franklin's roots are in Detroit, Michigan, and she owned significant real estate in the Detroit area when she passed away. Now, there was a period of time where she lived in New York and a period of time when she lived in LA, but she moved back to the Detroit area in 1982 to care for her father. Interesting note about that, she had to care for her father after he had been shot in 1979 point blank in the face. So in 1982, Aretha Franklin moves back to Detroit and she begins accumulating some real estate in the area. And that real estate, it turns out, is pretty valuable. I'll come back to that valuable Detroit real estate in a moment because that's actually a principal part of these competing wills. But before we get to that, we need to talk about who is competing in court. Now, Aretha Franklin was not married when she passed away, although she had been married twice during her lifetime. This legal competition is between her 4 children. Aretha Franklin became pregnant with her first child at the young age of 12, and she gave birth to that child, Clarence. Now, after she had Clarence, just 2 years later, at the age of 15, she had her second son, Edward Franklin. Now, Aretha Franklin did not really like to discuss those 2 early pregnancies with interviewers. See, while Franklin was pursuing her singing career and, quote, hanging out with friends, her grandmother Rachel and her sister Irma took turns raising those first 2 children, although Aretha did visit her 2 first children regularly. Her third child, Ted White Jr., was born many years later. He's professionally known as Teddy. Her youngest child is named Kelf Cunningham, although he goes by Kelf Franklin, so you'll hear me refer to him as Kelf Franklin in this video. Interesting note about Kelf Franklin, he was born to Ken Cunningham, who was Aretha Franklin's road manager. Another small but important fact is that the youngest child, Clarence, allegedly has schizophrenia. And as a result of that, he's under a legal guardianship and is treated as mentally incapacitated. In reviewing the records, this appears to have been mostly a legal battle between the 2 latest sons, Teddy and Kelf Franklin. Also, bear in mind here, we're dealing with a very valuable estate When she passed away in 2018, the news articles suggest that her estate was valued in the neighborhood of about $80 million. The most valuable component of that estate is probably her musical rights. And in all of these competing wills, those music rights are basically evenly divided. So these competing wills are really about which of the sons will end up with the other assets, the valuable Detroit area real estate, her furs and other tangible belongings, her vehicles. And while that real estate may not be the most monetarily valuable component of the estate, that would be the music rights, it was still very valuable, and it was certainly valuable on a sentimental level to those sons. It was reported after she passed away that Aretha Franklin owned her condo in Detroit, which is actually where she passed away, but she also owned a couple of nice homes in an affluent area called Bloomfield Hills, and she also owned some lesser valuable real estate in Highland Park, Michigan. Aretha's home in Bloomfield Hills, her primary residence, was the most hotly contested. In fact, in court, the attorneys referred to the Bloomfield Hills residence as, quote, the crown jewel of her estate. So now that you know what's up for grabs in Aretha Franklin's estate and who's up to do the grabbing, let's talk about these three competing wills. So there are three competing wills, one 2010, one 2014, one 2018. Now, I want to start with the latest alleged will because keep this in mind, we're dealing with last will and testaments. That verbiage is important because typically the will that is dated last is the only one that matters because we're talking about a last will and testament. The most important part of this 2018 alleged will is that Aretha Franklin never signed it. And under most states' laws, an unsigned will is not worth the paper it's written on. If it's not signed, it's not valid. So this alleged 2018 attorney-prepared will has a lot counting against it. It wasn't witnessed, it wasn't notarized, and she didn't even sign it. So under most states' laws, this alleged will didn't really have a chance.
That's never worked.
You would just think of this as sort of an unsigned draft that she didn't get around to signing, probably because she thought it did not get to its final form. The attorneys who argue in favor of the 2018 will said, okay, yeah, maybe it's not valid under the technical requirements of Michigan as a valid last will and testament, but it sure does show her intent. And to show that it shows her intent, they point not only to the wording of this draft, but they point to the fact that there were a number of conversations between Aretha Franklin and the attorneys that were tasked with drawing up this will. And even more specifically, they point out that there were a number of voicemails from Aretha Franklin to those attorneys. Now, I'm guessing it was probably pretty dramatic and probably felt like the jury was hearing a voice from the grave when those attorneys played about 20 minutes worth of voice messages left by Aretha Franklin for her estate planning attorneys, where she's giving them all kinds of instructions about what she wants. So the side that favored that 2018 document says, listen to those voicemails where she clearly expresses her intent. And they argue that should be good enough. According to the Detroit Free Press, in these voicemails, the Queen of Soul sounds polite but firm as she spells out her requested tweaks and deletions for the drafted will. They're peppered with a friendly feistiness. In one case, she says that is a no-no when she's speaking about one clause involving a potential liquidation of a musical asset down the road. Also, this 2018 document basically gives the four sons equal shares of everything. Of course, Clarence's 1/4 share under this attorney-prepared will would not have gone to him directly since he's under a legal guardianship. That quarter would have gone into a newly created trust to benefit him. But the 2018 will, for all intents and purposes, was an even split among the 4 children. Let's do the legal analysis of this 2018 alleged will. There was no notary. There were no witnesses. It was not signed by Aretha. Now, those 3 things are basically fatal under most states' laws. If you don't have those things, under most states' laws, a typed will would not be valid. And while the attorneys who favored that will wanted to argue that the will showed Aretha's intent, I think the final nail in the coffin was the part of the voice message where Aretha Franklin actually said the exact opposite. In that particular voicemail, the Queen of Soul tells her attorney, quote, "I am not declaring this to be my last will and testament." We talked about the 2018 will. Let's move to the 2014 will. This is the wonky will. This will was found after Aretha Franklin passed away, and it wasn't found in a law office or a safe deposit box. No, it was found wedged and crumpled in a couch cushion in that primary residence. It was done on a spiral-bound notebook. It wasn't a typed will, it was a handwritten will. Now, quick note about that. You may hear me refer to that handwritten will as a holographic will because under the law, they don't call it a handwritten will, they call it a holographic will. So here you have this holographic will that it's almost unreadable. It's hard to make out what she's even trying to say in this. Part of it sort of badmouth attorneys. Other words in it, we don't even know what she was trying to say. But there are parts of that 2014 alleged will that are very clear. First of all, in the document, she says it is her will. And that counts for something because under most states' laws, in order for a holographic will to be valid, it needs to clearly be a will. It needs to be in the will maker's handwriting, and it must be signed. Typically, those are the requirements for a valid holographic will. Witnesses and notary under most states' laws are not even required. So in this case, it has sort of the basic components of a valid holographic will. It may not be pretty, but it was written by Aretha, signed by Aretha, and it says it's a will, so it seems to meet the requirements. Not so fast on that signature point, though. Teddy wants to say that actually it wasn't signed by her. One of the truly weird things about this will is the alleged signature was bizarre for Aretha Franklin. It wasn't her normal signature, and it has a smiley face. The reason that Teddy wants to fight so hard against this 2014 wonky will is because the 2014 wonky will gives a bit more to Kel Franklin and his family. Specifically, that crown jewel real estate, yeah, the 2014 will says that'll go to Kelf and his children. The 2014 will also says that the vehicles, including a Mercedes-Benz and 2 Cadillacs and a convertible Thunderbird, those go to Kel Franklin too. It also says that Kel Franklin and his children would get a disproportionate share of the furs and jewelry and other personal tangible items. So while the most valuable component, being the musical rights, are evenly split, Kel Franklin gets a valuable monetary boost from that 2014 will. And keep in mind that crown jewel property is of important sentimental value to the family. And so again, that's why Teddy is fighting so hard against the 2014 wonky will. Even Teddy White's own attorney in his opening statement admits, quote, "Yes, there's nothing that says you can't keep a will in a spiral notebook in your couch cushion."
I would agree with that.
Let me summarize the good and the bad of the alleged 2014 wonky will. It was in Aretha's handwriting. That's a required fact, and it was a fact that was not disputed in this case. Now, it was allegedly signed by Aretha Franklin, although the signature was in question. The 2014 will is really hard to read. In fact, in parts of it, it was difficult to understand what Aretha was even trying to say. Now, it was also definitely not done by an attorney, and that fact seems a bit unlikely because wealthy people and celebrities, they know how to get an attorney to prepare a will. In fact, Aretha knew how to do that. We know that because she started doing a will with attorneys. It was also done in a spiral-bound notebook, and it was found in the couch cushions after her death. So while the 2014 wonky will, sort of on the face of it, meets the legal requirements, it is a wonky will. That leads us to the earliest alleged will, the 2010 version. Now, this version was also handwritten, but this version has a lot more going for it. While this one was also undisputedly handwritten by Aretha Franklin, this one is just more understandable. It's more legible. It's more clear. It appears to be more well thought out in the way it's worded. There's no doubt that the signature on this 2010 document is the valid signature of Aretha Franklin. In fact, she signed it on every page. And also, this 2010 handwritten will also has a notary on it. So that's a difference between the 2014 will, which had a terrible signature and was not notarized, and the 2010 will had good signatures and was notarized. Also, the 2010 will, instead of having been found sort of shoved in some couch cushions like the 2014 will, the 2010 will was found in a locked cabinet. Now, there's no law or code or statute that says where a will is stored has any real legal consequence, but it certainly does point to intent. When a person keeps a document in a locked cabinet, that certainly seems to show an intention that this was a serious legal document. In looking at the contents of the 2010 will, it's very even, it's very equal. It basically says that everything will be split up in 4 equal shares among the 4 sons. Now, where there is a difference here is that 2 of the sons, in order to get their inheritance, they would have to get some business classes as a condition to receiving their inheritance. They would have to have a business education. Now, one of the sons that would be subject to that requirement would be Kel Franklin. So naturally, Kel Franklin is opposed to the 2010 will because under the 2010 will, he would not be getting that crown jewel real estate. And because as a condition to him getting that inheritance, he would have to take those business classes.
Ain't nobody got time for that.
So there you go. Those are the 3 competing wills of Aretha Franklin. The good and the bad and the ugly and the wonky. Now, which one do you think won? Let's break that down. This case was battled in court for over 4 years. In fact, it was nearly 5 years. The culmination of this case was in a jury trial in July of 2023. Keep in mind, Aretha passed away back in 2018. So her sons duked it out in court for almost 5 years. Now, while the legal disputes worked themselves out in court, It's interesting to note that the jury needed just 1 hour to deliberate and to come to a resolution as to which they believe is the true last will and testament of Aretha Franklin. After that 1 hour deliberation, the jury came back and said it was the 2014 wonky will that won. Now, none of us could be part of those jury deliberations to know what the jury was actually thinking in determining that the 2014 will was the true last will and testament of Aretha Franklin, but I can give some educated guesses. So let's start with that 2018 document. To me, it's pretty easy to disqualify that case because since that was allegedly a typed will, it had more legal requirements. It had to have been signed by Aretha, and it wasn't. It had to have been witnessed, it wasn't. And there was no notary. So while there may have been some sort of creative legal argumentation done by the attorneys about what Aretha Franklin intended, it doesn't really matter what she intended because the 2018 document did not meet the strict legal requirements for a valid typed will. And aside from that, I think they really got shot in the foot by that voice message of Aretha Franklin, where she specifically stated that she did not intend that 2018 draft as her last will and testament. So then, having disqualified the 2018 will, I think the jury then focuses on the 2014 will because they have to look at the one that was last in time. They don't get to look at the 2010 will without for sure deciding that the 2014 will is invalid. And I speculate that the jury looked at that 2014 document and probably thought, well, it's weird, but it checks the boxes. It meets those minimal requirements. It was written by Aretha Franklin. They made a finding that it was signed by Aretha Franklin, and they made a determination that it was her will. So as wonky as it might have been, it met those bare minimum requirements, so the 2010 document doesn't even come into play. And I speculate that's why the 2014 will won with the jury. But isn't it interesting that it took that jury less than an hour to decide who would ultimately get that $80 million estate? I'm quoting here, "I'm very, very happy. I just wanted my mother's wishes to be adhered to," Kel Franklin told the Associated Press. Quote, "We just want to exhale right now. It's been a long 5 years for my family and my children." And speaking of that 2014 will, one of Kel's attorneys said, "It says right here, this is my will." She's speaking from the grave, folks. To wrap this up, I'm an estate attorney. I've handled more wills and trusts than I can count. I've assisted a lot of families battling these issues out in court. This Aretha Franklin case is right up my alley. To me, this is just another case where a celebrity didn't prioritize getting her estate plan done. But I will say at least she had an estate plan, as wonky as it might have been. Bear in mind that nearly 60% of Americans will die without a last will and testament. So at least Aretha Franklin had a will at all. And I think this case also teaches us that merely meeting with an attorney and telling an attorney our preferences for a will is not legally valid as a will. Your will is going to have to meet the legal requirements under your state's laws, or your preferences or your quote unquote intent simply won't matter.